This is Dakota News Now.
Within the 15 sections and 55 subsections of Amendment A, there are an array of different subjects and different purposes. Any of them can constitute a single subject, but combined, they violate the single subject rule without question.
The single subject rule, as it has been applied by this court, has historically served as a shield, not as a sword.
A landmark case in the South Dakota Supreme Court boils down to a single main argument. Does the voter-approved Amendment A violate the state's single subject rule? Good evening. I'm Kelsey Passel.
I'm Brian Allen. The state's highest court hearing arguments today on the case centered on the legalization of recreational marijuana. That trial lasting about an hour, with the 5 Supreme Court justices playing an active role in questioning both the defendants and the plaintiffs.
Austin Goss was there and tells us more tonight from Pierre. Austin.
Good evening, Brian and Kelsey. Just a few hours ago, one of the most followed Supreme Court cases in state history happened right here. Now, all of South Dakota waits to find out what happens next with recreational marijuana. Defense attorney Brendan Johnson opened up arguments, drawing major attention to the fact that Amendment A passed by a large margin, and that the court shouldn't set a precedent of throwing out a settled election.
Under God, the people rule was a statement that was more than just words, but reflected the founders' belief that the power of government comes from the power of the people.
The plaintiffs, arguing on behalf of Colonel Rick Miller and Pennington County Sheriff Kevin Thome, said that the lawsuit was not about cannabis, but the rule of law. Justice Janine Kern drew attention to the defense's argument that Amendment A had 15 subjects and 55 subsections.
What's the single purpose of Amendment A? Is it the legalization of recreational marijuana, medicinal marijuana, or hemp? Is it the funding of public schools, perhaps? Or revising our state's tax scheme? Or perhaps is it granting the Department of Revenue exclusive constitutional authority, which is something that's unprecedented in our state?
The sides also sparred over the matter of when the lawsuit should have been brought, before or after the election. The plaintiffs argued that they wouldn't have had standing prior to the election.
This court, from a policy standpoint, if nothing else, needs to say and articulate, you can't wait on the sidelines. If you see a violation, which apparently they did, from August 2019, the time to bring that is before the election, not after 400,000+ people have voted.
Now, should the Supreme Court rule in favor of Amendment A, recreational marijuana would be set to become legal on July 1st. However, the state would get until 2022 to set up the regulatory framework. Live in Pierre, Austin Goss, Dakota News Now.
Austin, thank you. As for when we might hear a verdict, that is still unclear. Both sides declined to comment on any possible timeline.
Today's case has been a long time in the making. Here's a look at the timeline of events leading up to it. On Election Day, 54% of South Dakota voters approved Amendment A. 2 weeks later, Governor Nome directed the superintendent of the South Dakota Highway Patrol to file a lawsuit arguing that the measure was unconstitutional because they say it violated the state's one-subject law. In February, a Hughes County judge sided with Nome, striking down the law. Last month, the backers behind Amendment A filed an appeal, which led to today's Supreme Court case.
We have heard from lawyers on recreational marijuana. Now we would like to hear from you. Head over to our website, dakotanewsnow.com, or open your Dakota News Now app and vote on today's poll question. Do you think recreational marijuana should be legalized in South Dakota? So far, our unscientific poll showing strong support for legalization.